speaking with me, Tarun Nangia, to we discuss the part 2 of our series on the enforcement of arbitral awards. In part 1, you saw Justice Sikri and the panel speaking on this issue. In part 2, we have 3 eminent gentlemen from the field of law who will reflect on this topic. What impact does enforcement of arbitral awards have on doing business in India? How investors in UK, US, Australia, Japan look at the enforcement of arbitral awards in India? What is the impact of delay on the ability of companies to settle their loans? The impact on the non-banking financial companies, NBFCs as we call them, to, in a sense, be able to recover loans from companies who, in a sense, are yet to receive award money. So we'll take a holistic view and what should be done. May I welcome Mahesh Agarwal, advocate. He is managing partner of Agarwal Law Associates. Advocate Mahesh Agarwal needs no introduction, a well-known name at the Supreme Court of India. You see his name in every other big matter. He also does a lot of arbitrations, and he has a view on the same. Good to see you, Mr. Agarwal, and looking forward to some interesting insights from you. I have with me senior advocate Gopal Jain. He does a lot of arbitrations, also appears at the Supreme Court of India, the NCLT, the NCLAT, Delhi High Court, and other forums. Good to see you, Mr. Jain, and looking forward to some interesting insights from you on this issue. I have with me Tejas Karia. He's partner and head of arbitration practice at Shardul Amarchand Mangaldas, one of India's leading law firms. He's an authority on this subject and will bring his own unique view to this issue. Good to see you, Mr. Karia. You have come on Legally Speaking for the first time, and I look forward to some. We've had so many discussions off camera all these years. I think on camera would be as interesting. Looking forward to have your presence and also your inputs on the show. At the outset, may I request Mahesh Agarwal that he could lay the ground of these issues. Mr. Agarwal, you are a part of high-pitched corporate battles which lead many times to arbitrations, and enforcement is an issue that is close to your heart in that sense. Could you first speak from the vantage point of what the corporates think of enforcement in India, and then we move towards other issues?
See, it's a very severe ordeal that after a long battle in the arbitration, the arbitral remedies itself should not be time consuming. There is normally a time limit of 18 months, 2 years, but they go on forever. Then there's a challenge procedure, 34, 37 appeal. After all that is over, the real battle starts that a person has to enforce. Now, the whole purpose of the dispute settlement mechanism is for the person to get the fruit of success, which is the decree, and then enforcement of the decree. Now, the problem is that the Supreme Court and the High Courts, in various judgments, have repeatedly said that the state of affairs is very sorry. There should be an expeditious disposal. Courts have fixed time limit of 6 months. They have appreciated and directed lower courts to enforce ASAP. But practically on the ground, nothing is changing. Despite summons from the courts above, and even the parliamentary legislative policies also to enforce as fast as possible. But on the ground, things are not changing. What is happening as a result of that is that things are getting irreversible for many corporates. What happens? You have an award with, say, NHAI or with some government corporation. You fight for 5 years. The amounts are huge. Now, if you're not able to recover the money from the contracting party, what happens? You're not able to comply with your obligations to your lenders, employees, vendors, etc. And today what happens is that you face an IBC process, an insolvency. So for the reason of non-payment by a losing party, you face an irreversible death. You may face an IBC. Supreme Court has in one judgment of Vidarbha, which was kind of criticized, also said that for reasons beyond control, if you're not able to pay, then should you go take to IBC or not? So legislative mandate is very clear that reasons don't matter. IBC will trigger in if there's a default. In a situation like this, where a person who wins the matter is entitled to recover and goes through a death, that is totally unacceptable. Now, this is being viewed very, very seriously by all corporates in India and, of course, foreign companies. Some solutions have to be found.
Okay, thanks for that opening comment. I'll take this to Tejas Karia from Shardul Amarchand Mangaldas. As head of arbitration, I think your mind is occupied 24/7 by enforcement issues. You might be part of many of these arbitrations. What is the view that the clients have? What is the view that the investors have? Where does that keep India's image, in the minds of the investors if enforcement becomes a problem? Your opening comment on this issue.
Thank you, Tarun, and it's my pleasure to be on your show for the first time, and I'm looking forward to many more opportunities. Coming to straight to the issue, enforcement. Yes, we have put a lot of focus on the courts for enforcement, but somewhere we are forgetting the role of arbitrators also in terms of the enforcement, and I'll tell you why. Is that arbitration is as good as the arbitrators. And if you don't have the award, which is impeccable and which is enforceable, then obviously courts are going to interfere. So to eliminate the role of the court, of course, I'll come to the problems we are facing with the court separately. But we should start thinking of enforcement at the time of appointment of an arbitrator itself. And we should only appoint arbitrators who are able to pass enforceable awards. And during the arbitration also, we should always think that the arbitrators and the parties should ensure as a team to ensure that the award becomes enforceable. Of course, there is one party who would not like the award to be enforceable because they want to delay, they want to get the benefit out of the award if they are not successful, and they would like to challenge. So the challenge and enforcement go hand in hand. So if we eliminate all the grounds of challenge, the award becomes enforceable automatically. So we need to ensure that the grounds for challenge are eliminated. So from day one, we know these are the grounds for challenge depending on the seat of arbitration. And we want to make India as the hub for international commercial arbitration. The fear we have in India and the problem we are facing is with regard to the enforceability of the awards. Because why enforceability of award is a problem? Because of the challengeability of the award. We have amended our act to ensure that there is no automatic stay of the enforcement. Today, we can have enforcement and challenge can proceed simultaneously without any difficulty unless there is a stay of the enforcement, and that stay also has to be granted upon conditional, and only in exceptional circumstances the courts are granting unconditional stay on the enforcement of the award. That has brought down a lot of frivolous challenges of the award. Many parties are settling after the award has come with the fear of not getting unconditional stay. They are offering a certain less amount, and parties are happy to accept it because they know that they are able to recover something today rather than after 10 years. It is also creating a lot of impact on the business because the losing party wants to delay the enforcement because they are getting a cheap finance in form of an award, because the finance outside, which much as a higher rate, lending rate than the awarded amount interest on the award. So more delay, they can get to use that money for a longer period of time, and then ultimately they pay. So if they have to deposit upfront, if they have to part with the money in the court, and that can get withdrawn by the successful party upon, of course, against the security given to the court, we are seeing that many parties are trying to settle and enforce. That increases the enforceability. Other aspect is Vivad Se Vishwas scheme, where also we have created that a mechanism where at least 70% of the awarded amount is paid upfront against security. All that has really helped. So we need to change the mindset in terms of ensuring that every stage of the arbitration, starting from the appointment till we reach the enforcement stage, we are only thinking of an enforcement and enforceability of it's a hanging sword on the head of the arbitrators that the award should be enforceable. It is not a paper award, because if you pass a paper award, you are no good because the fruits are only in the enforcement. And coming to the courts, now, of course, courts have a lot of measures which we have to take into consideration. The first is the cost, pre-deposit of the cost. Many times clients tell us not to challenge award in Singapore because they say we don't want to pay the cost because we know the outcome. So if you know the outcome of your challenge and you have to pay heavy cost to the other side, might as well you would like to comply with the award rather than challenging it. Time limits. We have the time limits. We have introduced that in our act. But are we able to do that? Is it mandatory or is it only directory? That also has to be seen because our court system is heavily burdened with the backlog of cases. We need to have specialist judges, specialist bench, or at least have one day in a week only for enforcement in all our courts. We have changed the definition of the court for the international commercial arbitration seated outside India, foreign awards is straight away going to the High Court. So we have done a lot, and these are my opening remarks. So definitely we'll discuss further as we go along. Thank you.
Thank you for sharing some very good points in your opening answer. I'll go to Senior Advocate Gopal Jain. Mr. Jain, you do arbitrations, but you also are part of Challenge to Awards in courts where you appear regularly for corporates. Give us a two-side picture of A, the dilemma of the corporates. Secondly, what happens in the court of law when these awards are challenged or enforcement takes a lot of time.
So award is like a reward, and everyone wants to see the benefit as quickly as possible. As Mahesh rightly put it, the fruits of your hard work culminate in an award. It's like a reward. And my analogy is it should be like an ATM machine. The money should come straight away, which is the whole intent of our enforcement mechanism. This takes us to that simple question, why is it that this doesn't happen? And let me give a practical example of just a week back. There's a case in which we have an award of over 1,700 crores. When it went to challenge, the public sector undertaking says to the court, look, I'm a public sector undertaking, don't make me deposit the money. I'm good for my money. We said, look, that's not possible. So the court said, give a conditional stay. And they said, we will honor the commitment and pay the arbitral award in full after we lose our challenge. They lost the challenge at two levels. Then the argument comes before the enforcement court, look, all that you now have to do is to ask them to direct the deposit of money and release it to me. So they have the temerity to say, my petition to challenge that in the Supreme Court is on the way. And on this basis, the court gave them some reasonable time. Point I'm trying to make is you have to nip it there and then. The moment you see an enforcement and your challenge to the award is over, the money should be made straight away. And as Tejas was rightly giving the example, it's because the vagaries of our system, where the outcomes are unpredictable because of the different courts that it goes to, people experiment and take a chance. Why is it that in an overseas jurisdiction you don't do it? Because the law is very clear, both the challenge part and the enforceability part. If there are narrow grounds of challenge, courts ruthlessly enforce it. And on enforcement, they make sure you see the money, your assets are attached, etc. So it's an effective mechanism which works on the ground. So our whole intervention or approach should be, what is the ground reality and how do we address it? And that's where I think, as you said, the view from the corporates or anybody that I have won the race, I've been through a 5-year or a 3-year arbitration. You say we have an Ease of Business Act, effective enforcement, but I don't see the money. So court must take away any form of sympathy in this case. And like in the IBC, the Supreme Court has said there's no room for equity. I think time has come that enforcement must be rigorously and scrupulously made without the sympathy factor. But I find on many occasions that sympathy factor comes in. And that is not what a commercial ecosystem requires. It requires predictability and certainty. And I think that's where having a designated arbitration bench and a designated enforcement bench, like we created the NCLT for IBC, a specialized body, becomes extremely important. And two, for the Supreme Court also to clearly send a message, as they recently did in the electricity case where Mr. Agarwal had also appeared through an epilogue. They said frivolous litigation, addressed it to a particular stakeholder and deprecated that practice. So the moment the courts don't take 100% deposit in an enforcement proceeding or take time, if there is a consequence, then people fall in line. But if you feel you get away, be it a delinquent judgment debtor or a court process, then we have the situation, the pitiable situation that we face now. So when we talk of ease of business, our benchmark must be like a Singapore, where it is granted, taken that your enforcement will happen successfully and in quick time. So all this must be translated on the ground, though there has been change in the act and various judgments, but I think it is an implementation of that both in letter and spirit in a practical, pragmatic and commercial way. The winner gets the fruits or what he is legitimately earned. And that's the only way we can become a good hub of investment, because arbitration and enforcement are two sides. And if you remember the time when Singapore was made, I remember the law minister saying that apart from wanting Singapore to be a multi-plural society, they felt that they must have the most effective arbitration system. And I believe if there's any order which comes which is perceived as being anti-arbitration, they immediately change the law. So you know that that ecosystem is responsive. And I think the balance of convenience and the pendulum must shift to support the winner and not the loser. And one simple example is that we always in criminal jurisdiction talk of prisoners' rights important, but we don't balance it with the victims' rights. So the winner is really becomes the victim after going through the whole long drawn process. And I think lastly, as Tejas rightly said, challengeability and enforceability. So normally we think the baton for enforcement goes from arbitration to the court. But if your arbitration award is weak, then it goes through the process of challenge and perhaps it is set aside, enforcement never happens. So these two things must go hand in hand. And now the government itself is setting up institutional arbitration. And I think that also becomes important, that the whole process should really be driven by institutional arbitrations. So it's not ad hoc, both in name and in approach. And if that happens, perhaps the challengeability would be lower and enforceability will get greater traction. So these are some thoughts that I have.
Thanks for sharing those thoughts. I'll take it to Advocate Mahesh Agarwal. Mr. Agarwal, three things, be it Justice Dhananjay Chandrachud, the Chief Justice of India, be it Justice Sanjay Kishan Kaul, and other judges, be it Justice Suryakant, all of them have made their efforts in pushing arbitration. We are very hopeful because we have a Supreme Court which wants to, in a sense, make the arbitration system flourish, and they are making efforts for the same. Some problems or some issues which may need their attention, which I want, in a sense, you to explain, could be problem with the National Highway Authority of India arbitrations which are being challenged. Other, even small arbitral awards being challenged, which Justice Chandrachud only last week highlighted, when a 9 lakh rupee award was escalated to Supreme Court. But there are some other issues. Sometimes there is a tendency among courts to do justice. ADR is a mechanism where there are eminent arbitrators. This is many times retired judges. An award is in place. Now, is there a need to do justice once an award is pronounced, or the enforcement should be priority? Second, if even a government loses a case, maybe sometimes the choice of lawyers may be wrong. It is okay. But once you have lost an award, are you committed to settle, in a sense? Because in the end, you lose, you lose. Could you take us through this? Thirdly, we have this problem of NHAI contractors also, their payments being unnecessarily dragged to years and years where they are unable to pay the NBFCs at a later point of time. You understand this very well. You deal with these clients all the time. Could you take us through these issues? And you have any solution in mind, a practical solution which stops government officers from challenging every award till the Supreme Court in case the other party is the government of India or a state government? Secondly, sometimes courts interest to do justice or look into the award after it has been, it's before the courts. But is it necessary to look into every award and do justice? Your experience on these two areas?
See, there are two stages, even post-award. First is after post-award, there is a challenge mechanism which goes through. So whether or not the award should be executed pending challenge mechanism. Second part is once the challenge mechanism is concluded, right up to Supreme Court, should at that stage be there any delay in execution. So the two separate parts. Now, when an award is challenged, the court objective is to balance interests. A person who has lost an award, he may have some arguments. He would like to make arguments. And at that stage, should he be compelled to pay? That is how the court balances equities. Whether he should be asked to pay or not, they have a prima facie look. And second is once the award challenge is over, then what happens? Now, in order to balance interest, I think it is very critical that the challenge stage itself, before the challenge proceeds forward, there should be a security mechanism. One way is that you pay the contractor, which some judges may not like or the courts may not like. But at least there should be a deposit in court. There should be a mandatory 100% deposit in the court, like you do in the customs cases at every level, at the commissioner level, then the appellate level, there's a mandatory requirement to deposit 30%, 50%, 70%. So before you move forward with the challenge, there should be a mandatory deposit. Once the deposit is made in court, the interest of both parties are to some extent balanced. Because the person who has to recover money doesn't have to thereafter go for attachment of bank accounts, sale of properties to recover. Second is after challenge is over. After the challenge is over, the final court, which is upholding the award, say in Indian case Supreme Court, at that state itself, there should be a mechanism that the litigation should end. There should be some mechanism that when the award is confirmed by the apex court, straight away there should be execution under orders while upholding the award itself, so that a second round of litigation is avoided. Now, this classic failure of the entire arbitration system is the famous DMRC case, which is talked about so much. The arbitration started in 2013. The award came in 2017. It has been affirmed right up to the Supreme Court. Like Gopal said, in this case also, DMRC during the process said, we are good for our money. We are a government company. If we lose, we'll pay. But after all that, they have not paid. The simple thing is we are running a public service. If we are compelled to pay, the trains will stop. There'll be unemployment. What can we do? Can you take over the assets? All those fights are going on. So that is wholly unnecessary if at the stage of the first challenge, there's a requirement of deposit. So just a statement by a government body or even a private body that I'm good for money is not good enough. We have seen in India how difficult it is to recover money from anybody. It's a known fact. Now, initially we had SICA, Sikh Industrial Companies Act, that failed. So many vendors, employees, lenders lost monies. That was replaced by SURFACE. Then now we have IBC. Even in IBC, there's a loss of money. So what is happening is if I have to recover money from X, I initiate arbitration. In 10 years, when I actually get the fruits, that person may not exist. The company would have gone into IPC or liquidation. So at the stage of at least the passing of the award and the first level of challenge, there is no other mechanism except to make a deposit. That will help in one more way. If the losing party is made to make a deposit, there is a good chance that the entire matter is settled.
Yes.
As we all say, the incentive is to delay. If I do not have to pay money today, I will use borrowed money for other things and I will keep delaying and pay some minuscule interest after the arbitration. So the idea is to disincentivize delay in execution. The only method, according to me, is deposit.
And Mahesh, that will take care of enforcement, because the moment the money is there, after you lose up to Supreme Court, they can direct release of the money. So it becomes almost automatic. So it really is a win-win situation.
That is a fair point. We'll take this point to Tejas Karia from Shardul Amarchand Mandalas.
Yes, so I have a few thoughts on this. Is that as far as the challenge from public sector undertaking is concerned, there is a mechanical challenge which is happening of all awards, whether it is challengeable or not. And we just last week only we saw the views from the Honorable Supreme Court on that, is that every award need not be challenged just because it is public sector undertaking. The only solution, practical solution I can think of is setting up some kind of an advisory board for the public sector undertakings, which can take the decision. Because the problem is that the officer in charge is not able to take the decision whether to challenge or not. And this board can comprise of some former Supreme Court judges or Attorney General or Advocate General, as the case may be, and give an opinion on whether to challenge or not. So then nobody is responsible, and that is that hanging sword is taken care of any inquiry against the person who is taking the decision of that. Secondly, with regard to the enforceability, we have to also see that the interim measures are used in an effective way. Because yesterday only I just was smiling when Mr. Agarwal said that I won an award for 550 crores yesterday for a public sector undertaking. And the other side congratulated me and saying, good luck to you, the company is now in IBC. So I was just wondering that whether I should celebrate or I should say sorry to my client that it's a paper award. The fact is that the interim measures, even during the pendency of arbitration, we are finding it very difficult that the tribunals and the courts are not granting for amount which is yet to be adjudicated. And we need to see that that is taken care of. Even we have a provision under Section 9 of our Arbitration Act to go to court and get an interim measures post award before it is enforced. So we should ensure that there is a money in addition to what money comes by way of a granting a stay of the enforcement of award. We should also ensure that the money there is a security towards the award, which ultimately, if it comes, then we have some money to dip into. Third-party funding is also a big issue. We have not yet, there is no prohibition, but we have not yet legalized it formally. Hong Kong, Singapore, and UK have done it, but we are yet to do it. Hopefully, in the committee of Mr. T.K. Vishwanathan, which we are looking into all the issues we are facing with the arbitration, we are taking care of all these aspects, and hopefully we will plug these loopholes. Because what happens in third-party funding is also that the arbitration becomes very systematic, because there is a funder involved who is interested in the enforcement. Then only the funder will fund the arbitration. So enforcement is the key for third-party funding. And so long as we fix this particular aspect of enforceability, we are not going to get third-party funding, even if we make it formal by way of recognizing it in the law. So we need to think of a practical solution. Many arbitrations are not seeing the light of the day only because of lack of funding or liquidity and the fear of enforcement. Parties settle. Yes, mediation is a very good tool for resolving the dispute, but sometimes parties go for mediation because of fear of enforcement. They may think that, okay, we may be successful, but what's the use of that success if we are not able to get the fruits of that success? And that is where the mindset of the court comes in, is that they cannot look behind the award. The award has to be the final, and that is finality of award, which is recognized by our law. Many contracts say that the award will be final and binding between the parties, but when it comes to courts, they don't treat it like that. So if we have that, and we have uniformity across India, we heard in the part one that some courts were favored, like Delhi High Court. Yes, because they have original site jurisdiction. Of course, for foreign awards, we go to high courts. And wherever we don't have original site jurisdiction, in some high courts, we find challenge there also. Even though we are arguing the enforcement case before high court judges, they are not that well equipped with the Order 21. And especially in foreign awards, there are two stages: recognition and enforcement. First, we have to cross the hurdle of recognition under the New York Convention. Then we get into the enforcement, and then we join the queue of all the other decrees, which is also waiting for enforcement after years of civil litigation. So we need to create a separate track, fast track for enforcement. We need to rely a lot on written advocacy. We rely on too much on oral advocacy. We should put time limit on oral advocacy, because if you have had all the grounds written in by way of a skeletal argument or written submissions, then oral advocacy is very limited, because that's only that much you can argue in terms of resisting the enforcement or challenging the award. And if your award is, as I said, perfect, and there is no ground which the arbitrator has given to the court, and again, reputation of arbitration is impeccable, and that's what I agree with Mr. Gopaljan, is that ultimately is the institutions only who can run the arbitrations properly, starting from the appointment, during the procedure, and also scrutiny of the award. Today, we are not having scrutiny of the award, and that's why some of the challenges can be eliminated by the scrutiny of the award itself. And when I sit as an arbitrator, we underestimate that benefit we have of scrutiny, but small things like simple interest or a compound interest, we miss certain footnoting, and we are all humans as arbitrators. And we come with a lot of baggage of the civil procedure, as we call, when the arbitrators are from the judicial background, and they're one of those finest arbitrators. But the lawyers also should be considered as an arbitrators. We should open up the pool for the younger generation. They are the future of this entire arbitration. We are talking about arbitration bar. And once we develop that arbitration bar, we are going to see a complete different way of doing arbitration. Moment we do arbitration the way it is done outside India, even for domestic, we will see that enforceability becomes a matter of course and not a challenge, because it's all about the way we do arbitrations, which leads to the problem in terms of the challenge and enforceability. Moment challenge goes, there is no difficulty with enforceability because the courts have to mechanically find the assets and ensure that. And people will not let their assets go away just for some amount and they will start paying up. It's not about ability to pay. It's about mindset to not pay because you have an option not to pay. Moment we take away that option not to pay and you have to pay, and ultimately the entire economy will get benefited if we achieve some small changes in our system. We have achieved a lot, and I would like to say between 2015 and now there is a considerable change, and it's a change is constant. We have to ensure that we are able to continue with this journey of changing our mindset and the way we do arbitration. Courts have been supporting a lot. All the high courts, including Supreme Court, has been pro arbitration. We have achieved a number of good judgments where we have got good law which is laid down by the courts saying that the award should be enforced. But it's just the sheer process we need to just change in a way that it becomes streamlined and there is a smooth enforcement of awards.
Thanks for that intervention. I'll go to Senior Advocate Gopal Jain. Coming back to the question involving infrastructure companies, I want to know three answers from you. First answer would be one on infrastructure companies' dilemma. They have huge amount at stake whenever they bid with the government. If enforcement is an issue, will bidding itself become expensive? Would the infrastructure companies want to build in the cost of, in a sense that if there is an arbitration that they have to enter into, there is a risk that money will come much later. So will bidding costs as a whole go up? Secondly, promoters sitting out of London, promoters sitting out of New York or other jurisdictions who are heavily investing in India, what view they take of India with enforcement issues, news that comes on and off always in one form or the other. Third, we have a very dynamic Supreme Court with judges like Justice Chandrachud, Justice Sanjay Kishan Kaul, Justice Suryakant, who are making the right noises about arbitration. What can they do to send a strong message that the courts will support the enforcement of arbitral awards, that the courts are here to ensure that the arbitration ecosystem in India will grow and will flourish? And of course, we will take it to a level where we can say that a lot of arbitrations now do happen in India.
First, whenever an infrastructure company secures a project on the infra side, usually it's against a government or a government entity. I call it, they get two projects, the project and project arbitration. They both go hand in hand. Second, some of the infra companies have become past masters at making claims. So they also know that we'll only get X amount as contractual payments, rest comes from arbitration. So it's a well-oiled machinery. And for anyone who's commercially minded, they must look at these successful examples which have been well executed. Second, you said, how do promoters look at it? They look at it as a risk-reward ratio. They know that there's a higher component of risk in India, not that increases the bid price, because they can't be anti-competitive. To secure the bid, you have to be competitive, but they definitely build in that risk-reward ratio and the cost of delay in terms of realizing your dues. And therefore, they have to run a parallel, efficient arbitration by doing early stage claim spotting and good documentation to ensure that what you don't get from the project, your legitimate dues, you get by way of arbitration. Three, the names that you took, the Supreme Court is now a proactive, supportive of arbitration court. It has sent a strong signal. But I think the point that Mahesh was saying is what I always believe, that money should be released straight away in a time-bound manner. You lose your challenge, here is the enforcement, here is the direction as immediate consequential relief to keep with the intendment of ease of business. You will see your money straight away within a time-bound period. Just to draw a parallel, and both Mahesh and I have seen this on the IBC side, the court says any claim which was to be made or not made stands extinguished so that a new successful resolution applicant gets a company clean. And every day those claims are coming and they have to go through a round of challenge. Now, that is an utter violation. So perhaps in a case like this, a strong message in a good case, even to use contempt jurisdiction to send a signal. Anyone who dare defy, disobey something which is clear has a price to pay. I think a deterrent always works in India. And lastly, to end on a lighter note, if you had arbitrators like Tejas and enforcement judges like Mahesh, we won't need this debate because it will work smoothly and easily. So that's what we should really strive for.
Okay. Thanks for your intervention. I'll go to Advocate Mahesh Agarwal. Mr. Agarwal, health of the banks is always of concern to the government. Many times the health of bank is contingent upon infrastructure companies which require big funds. They are the biggest consumers of loans. Arbitration in India becomes commonplace in infra companies. Health of the banks is a collateral damage. Could you link the two and tell us what the courts can do to ensure that there is some special attention paid to infrastructure companies? Because $150 billion, if you take it in rupees, it will be about more than 15 lakh crore rupees are going to be spent on infrastructure creation. Funding is not an issue. Humongous amounts of arbitration and disputes are going to arise in the next 8-10 years because these projects have been awarded and, in a sense, the construction is underway. Now, with that kind of dispute, are we capable, are we, in a sense, as a country geared up to that challenge? Or what the Supreme Court can do, what message can grow across, if you can reflect specifically on the infrastructure sector?
You've hit the nail. In most cases, the claimant could be X, Y, or Z. But that X, Y, or Z is ultimately a borrower from a nationalized bank or some bank. So the real claimant in most cases is the bank.
Yes.
He's not named, but the money is meant for the bank.
Yes.
As a result of this, what happens is that a person who has made a claim, he's defaulted in his bank liabilities. It's obvious such huge amounts is impossible to pay until unless you get the award amount. So there, like I said, security mechanism, possibly at that stage, the relevant or the concerned consortium of banks could also be made a party and they can hold the money in escrow so that their dues are secured. Ultimately, the money of the banks has to be secured through the arbitration process. It should not happen that after 5 years, the promoter is unable to pay and the bank goes under. So the real stakeholder in all these infrastructure litigations is ultimately the bank. But I just want to highlight another contra view. See, what we are saying is maybe true in theory, that awards should be enforced, they should not be delayed, etc. But when you're sitting as a judge and you see a case where the contract value is 100 crores and the award value is 500 crores, the judge's conscience will not allow to enforce. At that stage, what should you do? That is a real question. We are running away from that question, but that is a real question. Now, at that stage also, all arbitration award, there are mostly two components. One component is a contractual claim. So there's some money is not paid, dues not paid under the contract. And second is damages claims. Now, what happens is sometimes the damages claims are inflated or very high or disproportionate to contractual claim. So at least insofar as the contractual claim is concerned, under the award, that should be enforced immediately. I think that will strike a good balance.
Okay, so the contractual claims, I'll take this point to Tejas Karia from Shardul Amash and Bhagatas. Tejas, do you think the point that Advocate Mahesh Agarwal made that the contractual claim should be settled immediately and damages and other claims, even the issue, I don't know whether, Mr. Agarwal, you're covering interest costs, because many times interest balloons so much that comes under question too.
No. So therefore, interest on contractual claim should be paid immediately.
Okay. I'm taking this to Tejas Karia.
Yeah, I have a slightly different view with respect because, ultimately the court has no power to...
Tarun, the contract usually it stipulates a rate of interest, or the tribunal under 31(7) can award a rate of interest. So principal plus interest, because it's a time value for money. So contractual, I think, includes that.
So then the figure includes interest.
To put the party in the position it would have been if that breach had not happened. or what we call restitution, would include the principal and the time value for money. That is one composite sum.
Okay, that's one composite sum. Over to Tejas.
Yeah, so what I was saying is that ultimately it is, I agree that the award has to give reasons, because all awards have to be reasoned award. And so long as there is a reason and the award is not set aside, or there is no stay of the enforcement, enforcing court cannot decide on the merits of the award, is that what component should be given because of it is a contractual claim and damages should not be given, because as an enforcing court, the job is only to ensure that the award is properly passed and whatever grounds are mentioned for setting aside of the award are taken care of by that court. When the problem comes, why the problem comes with regard to this inflated claim is also we don't use experts in arbitration the way we should experts for, because most of the time arbitrators are not experts in quantification. We have delay analysis expert, we have the damages quantification experts. We can do hot tubbing of the experts also in front of the arbitrators so that we know exactly what is the amount in dispute and what should be the awarded amount. Because there are two aspects. One is the liability and the other is the quantification of the amount which should be given. Many times we see that there are awards which are passed on the basis of the statutory auditor certificates that this amount is spent without even verifying that what was the actual amount. And I quite see that every time you are bidding for a infrastructure project, you always calculate the cost of arbitration as part of your bid. Because that day one, if you see the correspondence also from day one in all these infrastructure projects, we can imagine that they have already planned for arbitration for delay in handing over of the site, extension of time, and also the idling charges for the machinery. All those claims are very standard, and they start writing correspondence so that they build the case over a period of time so that they can recover the cost which they would have quoted. And to become L1, they have reduced the cost, they recover it by way of an arbitration. If that is the mindset, we have to understand that what is the amount which is due and payable. With the help of experts, if the arbitral tribunal has come to a conclusion that this is the amount, then the enforcing court should give that amount. And there is no way that the enforcing court can bifurcate that this amount should be paid first and this amount should be paid second. Because ultimately then we are allowing one more layer of arguments available there to say that what should be the amount which should be paid first and what the second, and then there will be appeal against that order. We need to put an end to this hierarchy of litigation. Basically, we cannot have an arbitration as only a first step to the litigation. It should be the first and last step. And the courts are only in a supportive role. The role of court is not to sit over the judgment, over the arbitral award. As we heard in the first part of your series is that it is only one bite at the cherry. And that bite has to be taken care of by the arbitrators. And court has no role to play whatsoever other than ensuring that the award is not against the public policy of India. There is no patent illegality in terms of the domestic arbitration, and procedurally whatever grounds are there. The same grounds are there for resisting the enforcement of a foreign award. If we are clear on those grounds, and so long as those grounds are not available, and the award is reasoned award, then there is nothing to resist the enforcement, and enforcement has to follow. Therefore, I feel that we need to put a lot of emphasis on the process which we follow for the arbitration, and just have the courts as only to support the arbitration process by ensuring speedy enforcement of the award.
Thanks for that intervention. We almost just about 5 minutes left. We'll take two final comments. Senior Advocate Gopal Jain, on the part 2 of our series on the enforcement of arbitral awards, your closing comment.
I think the key thing which emerges from what everybody says is you have to just get the job done. The moment you get the job done, you have confidence in the system. So I think we have the right law, we have the right judgment. It just should be uniformly and consistently applied in every case so that the winner gets the fruits of his victory. I think that really is the heart and soul of this whole debate. We can talk. And second, ultimately, it's a fight for money. So you should get the money that has been adjudicated in your favor, which I call commercial justice is what is the need of the hour. And 3, I think it's absolutely essential to have designated fast-track enforcement courts, because the more familiar they are and the more they do, it will become a well-oiled machinery. And that's the message which the court would have to send out, as you said, to investors outside or otherwise, that it's a smooth process. So it should be equal to a Singapore in terms of ease, convenience, predictability, and outcome. And given the fact that we are the leaders at the G20, it's time for India to set that benchmark, not just always be a follower, but this is a good benchmark to set given the capex which is going to go into infrastructure projects. We definitely don't want the system to be like it has been over the last 15 to 20 years. So it must be a new age, predictable, well-oiled, outcome-based system is what I would say should be the objective.
Thanks for that closing comment. Over to Advocate Mahesh Agarwal for his closing comment.
See, we should just follow what the Supreme Court has said. The Supreme Court has said that we are in a sorry state of affairs.
Yes.
Itself. Supreme Court has said the entire arbitration system is getting frustrated.
Yes.
Arbitrations there are examples where they have taken 30 years for execution. So what the Supreme Court has said must be followed by courts below. That will only give faith in the system. So what we preach, we must do. That's the basic.
In fact, I foresee a lot of our Supreme Court judges going on to become eminent arbitrators. If I can name a few, Justice Call, a lot of people are discussing that, we have so many judges who are going to become most wanted arbitrators, Justice Chandrachud, all these people, if they take up arbitrations, they're going to be flooded with arbitrations. The message is also, if a lot of retired judges do arbitrations and then those are investigated by the courts, it's a very sad reflection.
Very sad. You retire as the Chief Justice of India and the award is set aside by a district judge in some local court.
Yes. So it is concerning, to say the least. That is one. Secondly, one point came in what Tejas Karya said from Shardul Amarchand Magandas about L1. I think the whole issue of L1 bidding needs to also be relooked at. We have discussed this earlier also with many people. Is L1 the best bidding system for any sort of a contract? Can money be the only parameter on which things should be decided, or there are quality and procedural aspects to that? That's for another day. Yeah. I would like to thank Advocate Mahesh Agarwal.
Tarun, can I just make one comment? Like Mahesh was giving the NHI example, there's a judgment of the High Court which says NHI should not challenge the award on this ground, on a ground on which they've lost all the way up to Supreme Court. They raise the same plea in every ground. You see, it's practices like this which, as Mahesh said, the Supreme Court judgment should be followed scrupulously, and sometimes it's required with a whip. Otherwise, imagine the plight of a company. On the point on which it has lost, you'll have an entire new round going all the way. It clogs up the system and sends a wrong signal. So it just requires ruthless implementation.
So ruthless implementation, we look up to judges who have recently spoken on this issue, namely Justice Kaul, Justice Dhananjay Chandrachud, Justice Suryakant, who spoke on this issue. We look forward to more such comments from our Supreme Court judges who have encouraged arbitration in India. With this, we draw to a close our part 2 on the enforcement of arbitral awards. Our next series will be on the arbitration and mediation arbitration bill, which is before Parliament. Of course, there will be a lot of discussion on it finally before it becomes law. But look forward to that. I would like to thank Advocate Mahesh Agarwal, Advocate Tejas Karya, partner and head of arbitration at Shardul Amarchand Magandas, Senior Advocate Gopal Jain. You took out time, you enriched the discussion by bringing in varied aspects of arbitration, also what the business world thinks about this, also about how businesses and banks are affected and what view the courts are taking. It indeed enriches. We do our next series on arbitration of this kind 3 months from now, but appreciate your joining us. Thank you so much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.